Hi, my friend Suzanne here with Clever Poverty, where we talk about clever tips for tiny budgets. Moving along on kind of part 2 of my little van dweller series about being able to park on public property and do you have to answer the knock. I'm making a separate video here because the other one is just going to go too long and anyway. So the video today is about do you have to answer the knock and what are the laws that say probably not. And I'm telling you, as I said in my other video, I'm not a lawyer. I am not a lawyer. So do not say, don't go do something, get in trouble and say, Suzanne, you ruined my life. Suzanne on YouTube said I could do this. Okay, use your own brains. You guys are smart. So, just the disclaimer there, not lawyer. However, I do have a bachelor's degree in law, but not from Harvard or anything like that, okay? And I'm a research freak. I like to look up the laws, and I've been very successful at looking up laws and taking care of myself without a lawyer. I've even fired lawyers because they were wrong about the law. and then presented what I believed was correct and won. So, anyway, so that doesn't make me an expert, especially on constitutional law, which I never really studied formally at all. So anyway, I like looking this stuff up. I like analyzing it, and I can tell you what I would do based on my religion. As I was talking about separation of church and state in the last video, I can tell you what I would do based on my research and education, and then you just have to make your own decision. So, my goodness, I'm just being silly. Okay, so do you have to answer the knock? Now I'm gonna have to change my glasses again. I can either see me up there or see the screen here with these glasses. Okay, so now ignoring the knock. And this is kind of like a part 2 about, I did the video about can you park on public property? Yes, it looks like it, depending on where you are, especially in the Ninth Circuit, like the Western states. Watch that video too, because that talks about your right to be parked on public property, focusing on van dwellers, people in their cars, sleeping in their cars. And then of course, you have to follow that up. Like that law says that if there's an available shelter bed, you're supposed to go to the shelter. You can park on public property if there's no available shelter beds that are not religion-based shelters. So, okay, what happens if there are available beds and they knock on your van to say, we have an available bed, you have to go stay in the shelter, and you don't want to. I wouldn't want to. So I would not answer the knock, and the reason I believe that's legal is actually based in some fairly recent case law. It goes back to old law anyway about unreasonable search and seizure. But there's some recent law about this in particular to homeless people that is relevant, that you could bring up if you ever needed to. So let me just, before I forget, just say that the case I'm going to talk about in particular that was just decided in Washington State, 2017, looks like. So it's the state of Washington versus Pippin, Pippin. And if you go to Google it will usually just say state versus Pippin, because they'll just take the usually like the last name of the person. So in this case, instead of going state of Washington, they just say state. They just shorten it. So state v. Pippin is the case I'm talking about. Okay, so it says, a warrant is required to enter a houseless person's tent home even if erected on public property in violation of local law. So basically what they're saying is that that person has the right to, we're talking about the Fourth Amendment in this one. And it's about your right to privacy. Now the courts, they're all really afraid of being the court that says that your tent or your vehicle is your home. They're so afraid of making that definition related to the Constitution. None of them want to be the court that made that final, yes, it's your home. So now there's no more question about that. They didn't want to go there, but it basically did the same thing. So what they did was they said that you have the right to privacy. So in this situation, the guy was, the police were coming and clearing out, they wanted to clear out a homeless camp. And what they did was they, this was in Washington State, and the police went up to this guy. He had created like a shelter with a tarp. So that's what they're talking about, tent. And the police said, you know, would you come out so I can talk to you? Which they can do. They can request that. And before the guy decided to come out or not, a police officer lifted up the tarp and looked inside the tent and saw that the guy had methamphetamine drugs next to him where he was lying down, and they arrested him, convicted him of the drugs and stuff. Now the law will say that if he was in a regular house, that would have been a violation. You need a warrant to look inside someone's house, to open the door and go inside. That would be an illegal search and seizure. Basically, it bites them in the rear if they do an illegal search or seizure. Then they can't use that evidence. So the guy did get convicted, but it got overturned because they said that he has the right to privacy and with regard to his property. So that's what it was about. So instead of a right to privacy in your home and your illegal search and seizure in your home, they went to the part of the Fourth Amendment that talks about protection of your property rights. So, you know, the tent was his property, so they violated the privacy with regard to his property, which they were only going to call a tent instead of his home. You know, so anyway, but it did the same thing. So just so that you know, why not? You should know this. So the Fourth Amendment says this. Excuse me. The right of the people to be secure in their persons, like, you know, your clothes, your pockets, houses, papers, and effects, against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So what that says is he needed a warrant. He needed to go get a warrant. And to get a warrant, this is what a warrant is. A search warrant is a written document that allows peace officers to enter a person's private property, home or vehicle, to look for, and somebody else wrote this, anyway, to look for evidence of criminal activity or to look for an individual who committed a crime, a search warrant must contain 4 elements: probable cause. Now, the police officer had no idea that that guy had methamphetamine in there. He did not have probable cause to look for it or take it, okay? So the warrant has to say there has to be probable cause. And a judge is going to hold their feet to the fire and say, show me, because a judge isn't going to want to get in trouble, look like an idiot, that you have probable cause to search, okay? And a supporting oath or affirmation from an officer. That's where the officer puts his or her, reputation and career on the line by putting in writing an oath that they are sure they have probable cause. Okay, so this is a high bar. Okay, and they have to put a description. They have to be specific of the place to be searched and seized. And they have to get a signature of the magistrate. So, like, if they're looking for a person in your house who's like an escaped fugitive, for instance, they didn't have the right to look in your jewelry box, okay? Because they wouldn't fit in the jewelry box, right? So you can see where it has to be really narrow. And to deter the police from violating persons' Fourth Amendment rights, the Supreme Court created the exclusionary rule. The exclusionary rule says, any evidence obtained by the government in violation of the Fourth Amendment guarantee against unreasonable search and seizure is not admissible in a criminal prosecution to prove guilt. That's why the guy got off. Okay? So, now, can they knock on your door and say, are you in there? Sure. They're not violating anything by doing that. But what are they going to do to find out if you're in there for sure? Are they going to break the window? I think they would need a warrant for that, and they would have to go to the judge and say, now with all these rights about, things about homeless rights, was a police officer going to go to a judge in the middle of the night and say, I think there's a guy in his van who's breaking the law about homeless people not going to the shelter? And the judge is going to go, I'm so glad you woke me up at 2 o'clock in the morning because, dagnabbit, you're right. Let's break into that vehicle and rip that guy out of there because he's breaking the law about not going to a shelter. I don't think so. Okay. So as far as, so here's where being stealthy, I think, is still a good idea. In case there are available shelter beds and you don't want to go to a shelter, I would not want to. I would still be stealthy as far as, now, you don't have to worry about your vehicle looking like you live in it anymore at all. It can be a gigantic RV, okay? Because you have the right to sleep on public property. And if you're not in it, most places have a law where they're not going to tow a vehicle. You have the right usually to park your vehicle, I think even RVs, for 72 hours. But see, nowadays with all this fear about if I'm telling you, like, I think it was the city of Santa Clara, I was looking at their police website about this. and they're like hands off right now because they don't want to get sued. They don't even if it's a gigantic RV, as I recall the way I read it, my little disclaimer there is that they're gonna leave it alone. So, and they maybe, you know, they've got some mayor who's saying, well, you need to knock anyway and see if you can get them into the shelter because there are available beds. If you don't answer the knock, I don't see them doing anything. I just don't see them taking a chance. I mean, we're talking like, the cases that I've seen so far, you know, like over $500,000. Are they going to take the chance that you're going to go to? And these legal aid, they're hot to trot now because now they have a case that shows they can win. So now they're not putting their entire budget on the line over a case that they may not win. Now they're feeling really confident. So and these municipalities know that, you know, so I just don't see it. I wanted to mention one other thing about there's a law about expectation of privacy. So here's where, again, you know, you might feel like you don't have to worry about them being able to look inside your van. Another thing about there's a thing called expectation of privacy, and that is if somebody, let's just say if you don't have curtains on your van and you're at a table chopping up drugs or whatever, and people can just walk by on the street and look in, anybody could just look in and see what you're doing, you do not have an expectation of privacy, and then the cops can get you. Okay, so you could Google that if you want to. This is probably going on like 100 minutes now already. Oh, we're at 18. Okay, good. So it was good that I split these into two. Okay, so you want to, if you put curtains up, now you have an expectation of privacy. So if somebody comes way up close with a flashlight trying to see in between these two curtains, and they're saying, ah ha ha, I could see you chopping drugs up. It's kind of a bad example, but I mean, kind of extreme, but you get the point. You're smart. Now, can they say that you did not have an expectation of privacy? Like, is the average person just walking down the sidewalk going to be able to look in and see what you're doing? Now, if you have to go to that extreme to see in there, it crosses that line as far as like even illegal surveillance, right? Because that's part of, like, you know, an expectation of privacy. So in my opinion, if it was me, I would go ahead and park on a municipal street, especially in a city that's big enough where you just know there's no way they have enough available beds, so they're just not even going to bother you. And I would also go ahead and even if I'm in a gigantic RV, if I've got a big truck pulling a casita trailer, you know, or, you know, it's obviously, I'm probably in there, I wouldn't worry about that at all. But as far as stealthiness, I would make sure I had an expectation of privacy by putting up, limo tent for one, but I would also, I'd go beyond that so that in case it ever gets into a courtroom, you could be like, look, I almost said dude again. I don't know why I keep making these videos. I'm gonna go dude. Which is so dorky for an old lady, and the word dorky is also dorky. But anyway, so I would just want to say, I've got, dude, the limo tent and curtains. Like, if that doesn't give me an expectation of privacy, nothing does. So you have Fourth Amendment rights as far as the right to privacy for your property. They don't want to call home, but it's property, and that includes tent. They use the word tent, so that's pretty clear there. And what that says is then they have to get a warrant if they want to come in. So if it was me, I would not answer the knock. I would put curtains and limo tents or whatever I could to make sure I also had the expectation of privacy, which was not addressed in this, but it's just something I learned. And that's my story. So I hope that was helpful. If you haven't seen the other video about the case law that says you have the right to park on public property, at least in 9 states and 2 territories, and on the western side, and Austin, Texas so far, and Denver, Colorado so far. You can go and learn about that law and your rights as far as being able to park on public property. So if you have other issues that you want me to discuss or look up, let me know. Give me ideas, share your stories, and like and subscribe, hit the notification bell, yada yada yada. Have a great day, you guys. I'm going to take my dog to the park now. I'll see you later. I wish you all the very, very best from the bottom of my heart. Take care. Bye-bye.